The legislature's back in order. Senator Ogden, you're recognized.
Good morning, Mr. Speaker, and good morning, fellow colleagues. Mr. Speaker, I'd like to move to resolve into the Committee on the Whole for the purposes of deliberating and addressing matters on Bill number 204-34 COR as substituted by the Committee on Appropriations and Adjudication, and that the Committee on the Whole extend an invitation to the Superintendent of Education to specifically respond to questions as it applies to the legislation.
On the motion, Madam Vice Speaker.
Mr. Speaker, I would ask that we also invite the Department of Public Works Director so that he could inform us as to the status of the ongoing procurement.
Okay. Have your staff start calling. And is there any objection to resolving into the Committee of the Whole? Senator Espaldon.
Thank you, Mr. Speaker. Mr. Speaker, I don't have any objections. However, I'm just wondering if it'd be prudent for us to also invite perhaps somebody from the Office of the Attorney General because of the legal consequences. And again, I'll leave this up to your discretion, Mr. Speaker, because I believe because there's an ongoing protest, there have been several steps, and we've changed it several times, whether there are any legal consequences if we go down this road and adopt this bill. But I'll leave that to your discretion, Mr. Speaker.
Yesterday, I thought we were planning who was supposed to be coming to this. I was not sharing. Who do you want in the Committee of the Whole? Otherwise, we'll just go straight to the bill without the Committee of the Whole.
The Superintendent, Mr. Speaker, I did mention a little yesterday that, in fact, an invitation will be extended to the Superintendent of Education, and then there's been a added request for another individual to join us.
Senator Nicholas.
Thank you, Mr. Speaker. I share the sentiments of one of our colleagues concerning the issues regarding the involvement of the Public Works Director with respect to the potential protest that's being adjudicated. I do understand that the invitation was extended to the Superintendent effective yesterday, and they are present. I understand the Public Works Director is not present. And the invitation could be extended to them, but I'm of the mind that if they do come here, they'll probably just tell us that they cannot comment on it because it's currently being adjudicated. So I would advise that perhaps we proceed with the Superintendent's presence, because the matter is predominantly a bill to transfer the responsibilities of the rebuilding of Simon Sanchez to the Department of Education.
All right, we'll resolve into the Committee of the Whole. You'll be responsible for contacting the two if they can't come or aren't coming, or for one reason, then we'll start. But at this point, we'll take a recess, and when we come back on, we'll be in the Committee of the Whole to discuss this. The Committee of the Whole is called to order. At this point, we have one matter before us, Bill 204, introduced by Senator Aragon. I want to thank the Superintendent of Education for being with us today. We are currently trying to reach DPW and the Attorney General to see if they'll assist. Okay. Senator Aragon, you're recognized.
Thank you very much, Mr. Speaker, and thank you, colleagues, for considering Committee in the Whole and also the placement of Bill number 204, that's 34, on the agenda today. Just so that the public understands in regards to Bill 204, that's 34, this is relative to designating the Guam Department of Education as the procuring entity for purposes of any solicitation respecting the construction and or renovation of Simon Sanchez High School under a long-term leaseback, changing definitions respecting responsiveness, and authorizing GDOE to solicit for architectural and engineering design, development of a comprehensive capital improvement plan, construction management, purchase of collateral equipment, and long-term capital maintenance planning. So that's the legislation that we have before us as substituted by the Committee on Appropriations and Adjudication. Mr. Speaker, Mr. Chairman, you did mention about the other entities that were extended an invitation. Just for the information of the body, DPW was contacted. They should be here in approximately 10 minutes. They were in transit about 10 minutes ago, and they informed us that they will be down here in about 20. The Attorney General, Attorney Carl Espadon, the invitation was extended, and he said he's going to have to consult with the Attorney General to ensure that it would be proper for him to join us this morning. And also, Mr. Speaker, the Guam Economic Development Authority representative was contacted yesterday with regards to possibly joining in the discussion. And at that time, they informed us that because of the ongoing activity with the protests, that they will not be able to join us in this conversation. So, in this discussion of Bill number 204. Mr. Speaker, I know that Mr. Fernandez would be an excellent individual to be able to talk about Bill number 204, but I want to say this much, that as we look at Bill 204, and we recognize the history of what has transpired over the course of the last 5 years. There have been 3 separate RFPs that have been extended out to the community, of which 2 were protested, all 3 were protested, 2 of which were successful in their protests, and unfortunately the government had to go back to the drawing table, and then now we have the 3rd RFP that was let out sometime last year, which is now under protest. So that particular process is going through the OPA, and that's one of the reasons why a number of the individuals, representatives, and government agencies who were asked to join us have shown some hesitation in terms of participating in this discussion. Mr. Speaker, I want to first of all thank your committee. This is legislation that you as chair recognize that we have to address the issue of ultimately having the construction of a new Simon Sanchez High School, proceeding with that particular process. And as a result of the introduction of Bill number 204, that's 34, you conducted 3 separate public hearings. 2 were held on December 5th, 2017. 1 was held in this body, and then the second one in the evening was held at Simon Sanchez High School to accommodate the students as well as the community of that particular school. After the presentation and the recommendations that were provided with possible changes to Bill number 204, that's 34, amendments were made with the collaboration of the Department of Education with the superintendent, and then your committee conducted a subsequent public hearing on February 14th here in the legislature, which was also very well attended by a number of the students and representatives from Simon Sanchez High School, inclusive of the superintendent as well as board members. So I want to thank you very much for that open process and allowing the community to be able to provide feedback in regards to the importance of proceeding forward with building a brand new Simon Sanchez High School. I want to also highlight that our colleague from Manila and also members of this legislature, inclusive of prior legislatures, Mr. Speaker, have been actively working with legislation to be able to try to support the procurement and moving forward with the construction of the school. And the most recent was in the last legislature, and then also This is another version that would allow for the transition and the assumption of the responsibility for the procurement to be transferred from the Department of Public Works over to the Guam Department of Education. Also, Mr. Speaker, I think it's important to note that in this case, with the ongoing activities, that we need to move forward with the construction of a brand new Simon Sanchez High School. We understand the circumstances. Unfortunately, that's in the past. We need to be able to move forward. We've discussed actively with the superintendent and Department of Education if they can assume this particular responsibility, and they have shared with us repeatedly based on some of their suggestions to modify the legislation so that they can be able to aggressively move forward, subject to the ongoing activity, the conclusion of the protest that is presently before the OPA. So, Mr. Speaker, I conclude my opening statements with that, and we proceed with the discussion on Bill number 204. If it's okay with the chair, then I would like to ask the superintendent if he can provide some general open comments and then proceed.
Thank you, Senator, and members of the Committee of the Whole, Mr. Speaker. I just briefly would say that the Guam Department of Education is in full support of Bill 204-34 as substituted by the committee. And I think it does two things that are important to us. Number one is it provides GOE the authority to lead and to complete the procurement for the renovation of Simon Sanchez High School. And number two, it provides the flexibility needed for us to successfully procure the services needed to make it, to ensure that it's successful. So, and with that, I just want to thank the staff of the committee and the Senator for working with our department and at least giving us an idea of what was trying to be accomplished, raising questions, soliciting input, but I think ultimately going with the recommendation of the department in terms of how to proceed moving forward. And I think that's important because if we are going to be given the lead responsibility, then it would be nice to know that and our recommendations were fully considered and adopted, and then allow us to be fully accountable for completion of this project. I also want to thank the legislature and the committee for holding the hearings, not just here, but at the school site. I think what ultimately formed the position of the department was the sentiments of the Simon Sanchez High School community and the trust and faith they put in the department to get this thing done and to prioritize Simon Sanchez High School as a top priority for the department. And so with that, I did testify before the committees in a couple of instances to accept that responsibility and to signal our willingness to be held accountable for ensuring that we can finally get this project done. Thank you.
I really don't think that we need to be so circumspect, Mr. Superintendent. I think we should be as forthright as possible with the people and with the legislature and take credit where credit is due, that the bill that's before us today is the bill that you and Senator Uggan wrote, and you should take credit for it and explain what and why the bill was written the way that it is, so that the members of the legislature understand why the bill is written the way that it is and what it is that you wanted to accomplish with the way that you wrote the bill.
Thank you, Mr. Speaker. I'm not sure where credit is due. I think that once this project is completed successfully, we'll be able to assign credit appropriately, given that there's still a pathway forward to get this done. But yes, we did work very closely with Senator Uggan. When the bill was presented to us, we did review it, and then we provided our input as to what we would, if this responsibility were to be given to the Guam Department of Education, what should this bill look like in its final form that would give us a comfort level for how we wanted to proceed. So, I mean, if the committee would like to go through line by line as to what the changes are, I'm happy to do that. But essentially, I think the idea was be clear about the authority, number one. Number two was that we wanted the flexibility to approach the solicitation in phases, if you would like to describe it in that sense. And so the anticipated flexibility we're looking for is to be able to break this procurement up so that we can tackle what we think is a really key element, which is the design of this facility. A lot has been made with regard to whether we have been clear on specifications and needs of the Simon Sanchez community and so forth. And I would say that the Simon Sanchez community was involved in articulating the needs of the schools, but there's no better way to clarify specifications than to have an actual design at 80%, 90% complete, so then we can then take that and issue it out for, I think, what would be a more straightforward solicitation for construction and financing. So that's the additional element to this that I think would benefit the process. I think before it was we were all in on design, construction, financing, and so forth. I think in this, going forward, we would like to be able to take on the design work first, and that's articulated in the bill and the changes. And then once we're complete with that, we think we can move forward and have a cleaner process for the financing and construction. So I think those are basically the two elements that I would say are different in this bill compared to the prior versions of the legislation.
Thank you very much, Mr. Fernandez. Senators, unless there are any general questions or comments you would like to make, we're going to proceed section by section so that there's a good understanding as to what the differences are between the existing provision as well, or the existing law, as well as the proposed changes. Also, I will, as long as I'm sitting here, I will use the discretion of the chair / as the sponsor of the legislation to be able to provide comments and rebuttals as questions arise. So just FYI. Also, another thing is we like to make sure that we set the ground rules as it applies to this particular discussion, and it's not to circumvent or to minimize any discussion of this legislation. So please, it's to respect all of our colleagues and understand that we want to allow others to be able to be part of the conversation, and then I will come back to you once we conclude a round of any individual that signifies they would like to ask a question or present any comments. So we will allow our colleagues to ask a question. You will be given 5 minutes for that particular question on a section by section. I am going to try to confine the discussion, senators, colleagues, to issues related to each individualized section so that we don't get lost and talk about the whole bill as in totality. Okay, questions can be presented. I would like to, because of the individuals that have expressed hesitancy in participating in the discussion, to respond to any of the ongoing protests, please be mindful of the nature of our conversation. It's on Bill 204, modifying the process, transferring the procurement process over to the Guam Department of Education, and having every trust and confidence that the superintendent, Mr. Fernandez, with his team, will be able to see this through with the proposed changes in the law. On that note, I believe there was a question that was posed that wanted to be posed to DPW. I will allow that question to be presented because obviously we have a DPW representative here, Mr. Andy, and I believe he's already been sworn in by the Sergeant at Arms. Okay, Vice Speaker Talahi and then Speaker Cruz.
Thank you, Mr. Chair. Yes, I would just like to begin our conversation with a very accurate briefing for the legislature as to what is the current status of the procurement of Simon Sanchez and what is the status of Bill 58. And also, I would like to know, is the substituted by the committee version exactly the same as the markup version that we had a public hearing on in February? Or did the committee make any additional changes to this bill?
I'm sorry, Madam Vice Speaker, Bill 58 is?
We were in the middle of a procurement, right, for Simon Sanchez, and then I think we passed Bill 58 by override. But I want to know if that was ever implemented or not, because that was another so-called solution as to how to expedite the building of Simon Sanchez. And if So I just want to know whether that was ever implemented by DPW, or if we never got out of the original procurement, and if we are still in that original procurement, then we need to know what is the status. Where are we? So thank you for coming down.
Yes, good morning, Senator. Good morning, body. As far as Bill 58 is concerned, I'm not familiar with it at all. I don't know when it was introduced and if it had ever been passed into law or not. But I certainly can give you the update as far as where we are with Simon Sanchez and the possibility of finally getting that school built. In or about January, late January, we were with the OPA, CTI, Cortec International, obviously protested and appealed it to the Office of the Public Auditor. We had been going into special briefings with them, and we had actually set dates to see if we could mitigate the problem between CTI and the Department of Public Works. Unfortunately, Cortec International had taken their plight to the Superior Court of Guam. Now, the OPA cannot, in any power given to them or her, be able to address any of the concerns that CTI had regarding the protest, so because it had been taken to a higher level. So right now, with regards to the OPA, we are at a stay.
What would the effect of passing a bill like this while you're in the middle of a stay, what would the effect be on that procurement?
I'm going to assume that because it's under protest and it's gone to a higher level as far as the court is concerned, I don't think we can move forward on it.
With the
Madam
new
Vice Speaker,
procedure?
if we can ask the superintendent.
The reason
to
I'm
respond.
asking, Mr. Chair, is because that's what happened the last time, is when we passed Bill 58, we were still in the middle of a procurement, and so I don't think that DPW was able to utilize Bill 58, that solution, and yes.
If I'm,
Yes,
Mr.
Mr.
Chair?
Fernandez.
So just to confirm, I was trying to pull up Bill 58 before I comment on it. So Bill 58 was passed and overridden, and it was the basis underlying, or it was in place, and the solicitation that is currently being protested was issued on the basis of being in compliance with Bill 58, is my understanding from staff. So the issue was it didn't get that far down the road to be able to see the impact of some of these provisions. I mean, there were some definitional changes and so forth. It really got stuck in the RFI process, and the basis of the protests are on record with the OPA and with the court. I think the question you answered about whether DPW can proceed with it, DPW cannot proceed with it. In my interpretation of how this procurement law works, as the procuring agency, they are stayed from going further with the procurement until such time as these matters are resolved in court and at the OPA. So what is stayed is actually not just the procurement, but the OPA's proceedings are stayed because Cortec International brought an issue to the court prior to the OPA issuing a determination on the appeal. And so what my guess is that once the court renders a decision, the OPA may have to complete its proceedings, and then the procuring agency would then be able to determine whether it can move forward.
And that's one of the reasons. Thank you very much, Mr. Fernandez, and thank you for that response from the perspective of the government of Guam. And we understand and we recognize exactly where the existing protest is, but what we're doing and what we're discussing is an option now that's available to be able to transfer the procurement process of the Simon Sanchez High School to DOE, subject to the final resolution of that particular protest. So we recognize that, but in this particular case, because of what has transpired in the past, one of the biggest concerns has always been who has the greatest stake in ensuring and seeing this whole process through, and I believe that Mr. Fernandez already alluded to that a little earlier. It's the community of Simon Sanchez. It's also the superintendent and the Board of Education, providing them that tool to be able to move forward, subject to the conclusion of that particular protest. Any other questions or comments? Madam Vice Speaker?
I guess I just want to confirm one more time. So the original procurement was canceled or terminated, and then you did a new RFI? Right, in 2018? Was that in 2018 or
Right,
December?
if I could clarify,
2017?
so there was a procurement that was issued on the basis of with the current law in place. The RFI was a part of that procurement. So there was a question and answer period that the vendors, potential bidders, would be able to engage the agency on. And after that question and answer period was over, then the bids would be due. So we did not get to that point because I think that, as you know from the public record, the protest was filed in the at that stage prior to any bids being received.
Thank you, Mr. Fernandez. Any other questions or comments on Bill number 204?
If you could just confirm my other question
Madam Vice
regarding
Speaker.
the markup version versus the as substituted by the Committee on Appropriations and Adjudication version?
I have the mark. I don't know what she's asking. This is the circulated.
Madam Vice Speaker, the as substituted by the committee, because that's the appropriate title. So the markup version is similar to the substituted by the Committee on Appropriations and Adjudication.
Yes, but we had the public hearing on the markup version, so I just want to know, is it exactly the same?
That's correct.
Exactly.
Yes.
Yes, thank you.
Any other questions or comments on Bill number 204, that's 34, before we proceed section by section? Yes, Senator Nelson, you're recognized.
Thank you, Mr. Chair, and perhaps I'm asking the same question and it feels like we're going around in circle, but just, a concrete answer. Just to be clear that even though if this bill does pass, we still have to wait for the ruling in the Superior Court of Guam for this bill to be in effect? Or can we move forward without the protest of Quartet?
Right. So right now, if the authority were transferred over to the Guam Department of Education, and with these changes incorporated, the Department of Education would be able to move forward with this solicitation.
Okay.
That's my understanding. Yeah.
So we wouldn't have to wait for the Superior Court's ruling? No.
The Superior Court's ruling, so on the basis of what was filed at the Superior Court, there's a protest to the OPA's decision whether or not to disqualify the Attorney General's representative in the OPA hearing, is my understanding of that protest. That's not relevant to this matter. It's relevant to the existing procurement.
Okay.
At the OPA, what's being protested is the ability for the Department of Public Works to utilize certain information relative to notices of default to be able to utilize that in the evaluation of bidders. And that's the matter before the OPA. So those are two, and those are very specific to the solicitation that DPW initiated.
Okay, thank you.
Thank you very much, Senator Nelson. Speaker Cruz, and then Senator Lee.
Thank you. I think the Vice Speaker is still concerned about what we have before us. And I think the history has to be, and the two of you are going to have to come clean about it, because the bill was originally introduced by yourself, Senator Uggan, and I understand, with the assistance of the superintendent. And then when we had the first hearing, there were various suggestions that had to be made, that were made. And so the committee tried to address those concerns that were raised at the public hearing, the first public hearing before the legislature and up at Simon Sanchez. We then, the bill that came out was different enough than 204 as originally introduced that the committee decided to have a second hearing, which we conducted. Testimony was again received. You and the superintendent took those, and this is what is now before us today as substituted, is the version as was written, as I understand it, by the superintendent. And the committee adopted it as as the work. And so I think that should be clear to the committee.
Mr.
I mean,
Speaker,
to
the
the
version
committee
that
of the
we are discussing at the moment, and we do have the committee report that was reported out by your committee, with all due respect, is the version that is before us. So we can ask any questions with regards to what the changes were from Bill version 1 to Bill version 2, but we are discussing Bill version 3, which is right before us. So we're going to go section by section, and I truly appreciate the efforts of your committee, because you're absolutely right. When the changes were incorporated into the first version, it required an additional public hearing. The modifications or slight changes from the second hearing, in our humble opinion, did not require a subsequent public hearing. That's why we have it before the body. So we will proceed with our discussion on Bill 204-34. With that said, Senator Lee, or I'm sorry, Speaker Cruz, are you done with your statement?
That's all I wanted, so that this Vice Speaker understood that there are some changes in this bill from what was heard in the second hearing. And she's just asking, what are those changes? And I guess
my
you'll deal with them
response is that we will go
section.
section by section and ensure that everyone understands the changes that were incorporated into the entire legislation that is before us. Because the changes, subsequent changes, to me, the measure is before the body now. So we will proceed as this is placed, and we are in discussion at this point in time. So thank you very much, Mr. Speaker. Senator Lee, you're recognized.
Thank you very much, Mr. Chair, and thank you, gentlemen, for joining us this morning and being open to answering our questions. In light of the fact that we will be going section by section in this substituted version of the bill, I just wanted to, prior to doing that, ensure that, or if you could, maybe Mr. Chair or members of the panel, if you could point out specifically once we get to those sections. I know that there was an issue or a concern that was raised during the public hearing about two separate constitutionality concerns that were raised, principles of due process that might have been with regard to the bidder's right to a hearing. I just wanted to point that out, and as well as a separation of powers doctrine in the context of the procurement. So if we could be sure to highlight those as we're going along, that would be very helpful. Sujus Masi.
Thank you very much, Senator Lee. Any other questions or comments on the proposed measure before we proceed section by section? Senator Muñoz, you're recognized.
Just a quick question, excuse me. If the ongoing protest is resolved, why would there be a need then to change the procuring agency?
Should the protest not be recognized or be disregarded, then the process will continue as is. That's
Okay.
my understanding. Now, if the ruling is that the government of Guam has to go back and revert to another procurement process, then by virtue of extending the tools to the Guam Department of Education, they would assume that responsibility.
Okay, okay, thank you.
Thank you very much, Senator Muñoz, for your question. Senator Espadon, you recognize.
Thank you, Mr. Chairman. Just on the comment that you just made, you're saying that was in your opinion. What is the legal opinion?
1 minute recess, because I'm not going to pretend that I... The Committee in the Whole is now back in session. Senator Espadon, you had a question with regards to the ongoing protest, and should that be negated? What will transpire? Should this legislation receive the support of the legislature and be signed into law based on the legal counsel's advice, then this process would now supersede because it would automatically transfer the procurement process to DOE.
The procurement process will be transferred. However, I mean, again, I'm just reiterating your words. However, does that mean that by transferring that a whole new procurement process will take effect?
The answer is yes, Senator Espada. Based on the
and so you'd have to start from ground zero one more time.
That's correct.
Mr. Fernandez?
Yeah, ground zero meaning we start at the beginning of the process, but that doesn't mean we start with an absence of any information relevant to the solicitation. So we've done a lot of work already. It'd simply be starting the procurement process from at the starting line.
You know, I appreciate that. However, you know, the law as it's written now, because what we're doing is we're amending the law, right? And the law as it is right now actually does have the evaluation committee is DOE, DPW, land management, and GITA. So GDOE has been there always. Under this new version, excuse me, it'll be DPW, under the present version, it's DPW, land management, EPA, GITA, and DOE. Right? Under the new version, it's the same players except for EPA. Right? Under the existing law, DOE, the superintendent of DOE will be serving as the chairman. Under this legislation, DOE will be serving as the chairman. I guess, in my mind, if DOE has been there from the start, what changes? I mean, why wasn't DOE actively participating or at least having their input heard by all the other agencies as under the current law? And now we're going to change the law that basically just puts DOE, I guess, as the lead.
So,
but if DOE's been there all this time, what changes?
So, I'm sorry, Mr. Fernandez. Senator, I'm going to yield to that particular question when we get to that section, okay? Because I don't want the same question to be asked again. So, unless you have any general comments, we'll proceed with the section-by-section breakdown.
And that I'll concede to that. But again, in the end, sometimes when you go section by section and we're only addressing issues per section, it doesn't really give us the general overview to discussing as a whole. Sometimes the sum of the parts does not equal the whole. And so that's why I want to make sure, Mr. Chairman, that somewhere along the lines, if maybe at the end of this or towards the end, that we then get to ask the generalized questions to tie in all these various subsections. Thank you.
I will yield to your question when we get to that section. Senators, I think that one thing that we all recognize is that the process at this point in time, where it was and where it is today, just has not worked. Now we are exploring, not exploring, but we are considering transitioning this process to the direct stakeholder, which is the Guam Department of Education, who would have direct influence in terms of the process and the decision and making sure that we proceed accordingly. So in this case, in collaboration with Mr. Fernandez and GDOE, this legislation was formulated so that to the greatest extent possible that the superintendent will be able to see this whole process through. We've gone 3 times with a government agency in which protests were extended. And now it's time for us to look at a different option, and if the option is looking at GDOE, at the superintendent, believing that in fact he's going to take this and he's going to drive it to the point where in fact we have a groundbreaking and the students get what they deserve and what they've been asking for, which you have supported also, Senator, then we need to consider other options, and that's what Bill 204 provides.
I appreciate it, and then I have to at least make a comment. I supported it, again, knowing full well, you know, that our intentions were good. I just still don't understand what's going to change, because DOE has been at the table, and it has had the opportunity to be driving it from the beginning all the way to the end. And so by this legislation, that's still the question in my mind. What changes? Thank you, Mr. Chairman.
Thank you, Senator Espadon. Senator St. Nicholas, you're recognized.
Thank you, Mr. Chair. I just wanted to echo one of the sentiments of the previous speaker, in that there is something to be said about being able to talk about the bill in an all-encompassing fashion. For example, if we look at Section 2, it talks about the responsive offer means an offer that conforms to the solicitation. But we don't talk about what the solicitation is until we get to Section 4. And so it becomes kind of constraining to have to swallow Section 2 without even knowing or being able to talk about what the solicitation actually entails.
I understand.
So I would like to
there'll
just
be,
ask for some flexibility to be able to...
There'll be some flexibility, but just acknowledging that when we can come to, as an example, Section 2, that there will be an appropriate response as to why that is being presented in its present format. So thank you very much, Senator St. Nicholas. Any other general comments? Senator Rodriguez, you're recognized.
Thank you very much, Mr. Chair, and thank you to the representatives who are here this morning. Mr. Chair, I don't know if you can answer or anyone else here can answer. I know and you recognize that this body has, on numerous occasions, tried to find ways to finally get Simon Sanchez rebuilt. And so I recognize, and I recognize you as well, Mr. Chair, for this effort. However, to follow up in some of the discussions from our colleagues this morning is that what assurances do we have that transitioning from one government agency to now DOE would safeguard this process from any protest, if there's any safeguard?
Mr. Fernandez.
So this whole process is governed by procurement law, which is, and the procurement regulations that have been adopted that every procurement goes through. So I don't believe there's any way to, I think the initial bill, so let me clarify for the record, since the Speaker made it clear that he wanted to clarify for the record. The bill was introduced by Senator Uggan, and at that point, DOE, although we were aware that there might be legislation, did not participate in drafting of that original legislation. The reason you saw a lot of changes in the second draft was because of Senator Uggan's staff and the Senator reaching out and saying, can we make sure that you are comfortable with whatever legislation does go forward? And because we made some changes that we recommended, that was the reason why you saw the changes and a second hearing. And along the way, we heard good questions and good suggestions. There were vendors who were at the hearing who suggested different ways to do it. So we think it was a productive process. To guarantee against protests is very difficult, because the way the law works is that we guarantee certain safeguards for vendors to be able to challenge the procurement process. I think the goal is to try to minimize the opportunity for protests by ensuring that we try to ensure that the execution of that solicitation is above challenge, and that we try to ensure that we maximize competition and follow the tenets of procurement law and regulations. I think the one way in which we are aiming to try to minimize the opportunity for protests, there's two things that we're proposing. I think the legislature did the right thing first by saying, instead of issuing a $100 million solicitation, all or nothing, to one vendor, that I think by saying we're going to do this separately, and that's what the legislation did by Senator Atta in separating Simon Sanchez from the rest of the procurement. If you have $100 million at stake as a bidder, I would definitely set aside legal fees to ensure I maximize my opportunities to appeal that process, because there's a lot at stake. So I think one improvement was to basically limit it to Simon Sanchez. The other way we're approaching this is to break that procurement up even further. One of the challenges is that I think the OPA mentioned we didn't know what the DOE wanted, and we definitely provided a lot of information about what our school needs were. But whether that translated into specifications that would ensure that a construction bid and the financing for that construction was straightforward, I think that's where the questions arose. So what our proposal is to take that procurement and break it up even further by allowing the design process to go forward first. I think the design process is going to be a much more modest amount. We estimate that's pretty much going to be in the 5 to 10% range of total costs. That, so we're going to limit that number. Hopefully that minimizes the stakes at which these vendors are competing. I suspect it would probably be geared towards A&E firms who provide design services. With that design phase, we'll be able to ensure that we put more detail behind the specifications. We would be able to generate a government estimate of the cost that would help us to guide the reasonableness of the construction the cost proposals, and then involve the stakeholders in that design. And when we're done with that design process, we're going to tell the bidders in that next phase, build X. We're not telling you to design it yourself, come up with different concepts, and then give us a cost associated. We're going to say, this is what we've decided. It looks like this. It's this high, it's this wide, it's this broad, it's how many classrooms. It's going to come with, maybe hopefully 80%, specs being complete. So when a construction, when a bidder looks at this, they say, oh, we know what we're building, and we can generate a better cost estimate because we're not, starting at the concept phase. You guys are telling us what to build, what those detailed specs are, and here's our proposal. So I think that's, in a way, if we work this out, we do design first, and then we move into a solicitation for construction and financing that'll take place once we figure out what is it that they're building and financing.
Great. I appreciate that answer, and I have every faith and confidence in your leadership and DOE's leadership to move this forward. So my final question is this, and I caught the tail end of Mr. Leon Guerrero's statement about there's current protests right now that's pending. And so if that is resolved, this really just becomes another tool. It doesn't take us to what exactly you said, and which is a preferable way of moving forward. So is that correct? Is that statement correct, that if the current protest is resolved in a favorable manner and it doesn't move forward anymore with any sort of further a protest or litigation, then what we have in front of us now is what is going to move the building of Simon Sanchez?
Yeah, that would be totally up to the legislature. This bill, once passed by this body, if and only if we come to a conclusion with the OPA and the Superior Court of Guam, then this bill probably will take into effect, and the previous bill, this will be supersede the previous bill, and then will allow DOE to continue with the process for an IFB, and in this case probably a multi-step IFB to do both the planning and then the construction of the new Simon Sanchez. But Senator, going back to your original question about would it guarantee that there will be no protests? Nothing will guarantee that. With this amount of money that is being utilized to build Simon Sanchez, there's a lot at stake for a lot of the contractors involved here. Many protests are legitimate, but many aren't as well. So it just depends on the amount of money that probably would be made, and that would be the incentive for any contractor at any given moment to file a protest. Then going back to the superintendent's comment on the multi-step bid, it's great because it gives the DOE an opportunity to sit with the winning bidder for the design work of Simon Sanchez, and whatever input that DOE/Simon Sanchez has to build Simon Sanchez and to finally get the blueprint for it is great. But at the end of the day, the costs are going to be the same. You're going to have 4 contractors. Construction costs are going to be the same, so there's no advantage having that other than the fact that now there'll be input by DOE and the Simon Sanchez family to build JFK. Construction costs will always be pretty much the same, and they'll be relative to any contractor that decides to bid on the project. you probably won't get any savings there. But the advantage would be on the multi-step bid would be for them to actually design the new Simon Sanchez High.
All right, I appreciate that. Thank you very much, Mr. Chair.
Thank you, Mr. Leongor. Thank you, Senator Rodriguez. Senators, we're going to proceed section by section. Section 1.
Mr. Chair, before we proceed section by section, just as a follow-up on
Senator
that.
Espadon, you're recognized.
Thank you. If I could just ask, either Ms. Leongor or Superintendent, why wasn't a multi-step initiated in the present procurement that's being challenged? If that was the way to go, and it seems the reasonable way to go, anybody who's building a house would definitely go and get the construction floor plans first, the blueprints first, and then once they get that, they go to the contractors, say, give me an estimate, or can you do this, or whatever it may be. But, so the question is, why didn't we go down that road in the first place? Is there something that has prohibited? Is it the law that has prohibited this whole effort?
So it's my understanding that the laws that have governed this solicitation have changed in a number of ways. Initially, it was dictated by the law, which is, I'll explain how that's relevant to some of the changes that we propose. It was dictated in law that it would be, the method of solicitation was dictated by the law that was passed by the legislature. That law required the use of an RFP through DPW, and then included the work around the financing, design, renovation, or construction of the education facility under a leaseback arrangement. So it envisioned that all of these costs and activities will be paid for under a leaseback arrangement, which essentially means you're leasing it with one entity, is my understanding. So the reason why we suggested changes in this current law was to clearly separate and give flexibility to give the opportunity to the procuring agency to break apart some of these activities. Some will be funded by leaseback, through the entering into a lease with the winning bidder, and some activities like the design can be done separate and apart from this whole leaseback structure. Now that is a discussion I've had with the senator and with all of you. Our challenge right now is if we go down this route, is to get the authority to proceed with the design work, for instance. If this is approved, we would go out and try to move forward with solicitation for design. That, of course, would require funding from a different source. So that becomes an issue that we're looking at, whether it's an issue of what I prefer is working through the appropriations process and our budget situation to determine how much funding is needed and to make that funding available. But right now, it's working with the authority to change the method of solicitation to give us all the flexibility accorded to the agency under the broader GovGuam procurement laws and regulations.
Senator Espadon?
As a follow-up on that one, then what I'm hearing, at least one of the issues that I heard on this one, is that by separating it out and going multi-step and doing the design and A&E first, right, it would require a separate funding source than what is presently available to DOE. You said earlier that the A&E would probably encompass about 5 to 10% of the total cost.
Correct.
So we can anticipate how much?
So, I think we were looking between maybe $4 to $5 million was an estimate of what it would cost. Now, what we sought in the authority under this bill was to open up that source of funding that is currently set aside for the leaseback payments. So, the leaseback revenue stream is already identified and set aside by the government. Those funds have not been utilized for the lease agreement. Right, so every year they are identified and there should be set aside for that purpose. But until we enter into a lease, those revenues are not pledged and to support that lease. So it's been several years since this law has been put in place. We want to work with the speaker and the senator, our education oversight chair, through the appropriations process to identify and ensure that we can utilize the funds that are being collected there to support this effort.
And also, Senator Espadon, just to highlight, going back to your initial question about the multi-step, that was the product of part of the discussion with the transition from the first version into the second public hearing. And that was incorporated. It was recommended, highly recommended by the superintendent, and we concur that that would be the best approach in regards to making sure that we can bifurcate the A&E have that completed so that they can anticipate exactly what the anticipated cost would be for the actual construction. So that was a product of the public hearing. It's not a question of why did we not use that multi-step bid approach in the past. It was very actively advocated, and also the superintendent concurred that may be the best approach in regards to addressing this. So I appreciate your question. Any other questions, Senator Espadon?
I'll reserve it till later on. Thank you, Mr. Chairman.
Thank you, Senator. Okay, on section 1, any questions or comments? Legislative findings and intent? If not, I know that there may be some questions with regards to section 2. It now would read, responsive offer shall mean an offer that conforms at bid opening in all material respects to the solicitation. If I can ask Mr. Fernandez if you want to comment on that particular section.
Basically, what this proposes is to remove the language in the law that was passed, Bill 58, that set forth a very special definition of responsive offer, and we recommended that this special definition be removed, and that we resort to the definitions that are already contained in our procurement laws and our procurement regulations. So those are matters that have been adjudicated before this definition, the common definition already contained in our rules and our laws and our regulations have been adjudicated with the OPA and the courts in many past instances, I'm sure. So I don't think it benefits this process to have a special definition of responsive offer or responsive that does not conform to what is typically used in government procurement here on Guam. So it's not to remove the definition, it's simply to revert to the definitions that are set forth, I believe, in if you look at in the GAR, as well as in section 5201 of the Guam Code Annotated, Title V, which establishes the definitions for both responsible bidder as well as responsive bidder.
Thank you very much, Mr. Fernandez. Any questions or comments with regards to section 2? Senator San Nicolas, did that provide a response to your initial concern?
Thank you, Mr. Chairman. So section 2, basically, the language that's being stricken through is language that would have required the responsive offer to include in its offer certain clarity, certain items that would provide clarity, and that would include a breakdown of the project, which would include at a minimum the hard construction costs, the soft costs including management, development, and other related project fees, and the annual lease payment schedule identifying any financing, insurance, and maintenance costs and terms. I think those are the tangible items that are being stricken through here, Mr. Chairman, because everything from lines 8 through 12 that precede that, that's basically just very nice language that says, you know, the responsive offer is the one that's going to do what they say they're going to do based on what they're supposed to do. But it's this breakdown here that is, I think, most important, because this breakdown helps us to have a very clear understanding of what is actually going into the building, what is going into the management of that building, and what is going into the cost of financing that building. By striking all of that out, we're basically, with this amendment here in section 2, just saying that a responsive offer shall mean an offer that conforms at bid opening in all material respects to the solicitation. So any offer that conforms to the solicitation is considered to have met the requirements to be responsive. And that takes me, Mr. Chairman, to my concern with respect to page 4, section 4, what is a solicitation? And that's why I wanted to kind of be able to discuss what is a solicitation, because now all we're saying is so long as they conform to that, they're good to go as part of the consideration process.
Thank you, Senator San Nicolas. I'll ask Mr. Fernandez to respond.
So again, in section 5201 of the Title V, Chapter 5 of Procurement Law, it establishes a definition for responsibility and responsiveness. It goes further in the GAR to also articulate the same definition that a person who has submitted a bid which conforms in all material respects to the invitation for bids is determined to be responsive. I guess the one way to frame this, my suggestion that we stick to the existing overall law and regulations in place is that I would have to ask the author of the, this maybe Senator Ada was here, but for instance, as looking at the language that we struck, I would venture to say that it raises the probability of a protest by inserting language that I don't believe is familiar to those who are doing procurement typically within government. So for instance, and I'm just playing the devil's advocate, if I'm a vendor and I get to a point where I'm not awarded, I'm going to want to know how the agency interpreted the term unconditionally undertakes. I want to make sure that I understand what a complete breakdown means, what other related project fees should or should not have been included in that bid. And I will want to take apart this section because it's not typical. This is not included in existing laws and regulations. It's got this new language. So I think it's ripe as a vendor who may not be selected to figure a way to pry apart this new definition and make an issue of it to the OPA and to the courts, potentially. So that's my concern is every time we create a new definition, there's nothing for the OPA and for the courts to rely on in terms of past decisions because it's an absolutely new definition. So I would prefer that the OPA and the courts, in the event that this is protested, can look to their past decisions around areas of responsibility and responsiveness because I believe they would have a much more significant body of work to rely on. And I think that's how I would suggest we try to minimize the opportunities for protest.
Senator Nicholas?
Thank you, Mr. Superintendent. I do see the desire to minimize the opportunities of protest, but we need to balance that also with what would be in the public interest, because sometimes it's worthwhile to have something protested if clarifying that issue would have resulted in an improved outcome for the people of Guam. And so if there is a protest that's being levied because somebody did not provide clarity in their construction cost, or somebody did not provide clarity in their soft costs, including the management costs, the development costs, or the project fees, or someone did not provide clarity in their annual lease payment, or in the financing, insurance, or maintenance costs, I mean, those are very basic. If the offerer is not being very upfront with and is not able to clearly defend in a protest what their hard costs were, what their soft costs were, or what their financing costs were, that should not be considered as a responsive offer because then there's ambiguity into what those costs are. And that's, I think, those three categories are at the very least fundamental to knowing what it is that we're buying. I mean, it's like buying, if we were to go out and purchase, a car on a lease back, we want to know make and model, we want to know how much they're going to charge us for maintaining the car, and we're going to want to know how much the interest rate on the leasing of the vehicle is going to be. And if any car company out there says, oh, well, here's my bid, and we don't quite have a very clear understanding of what that is, then we really shouldn't be doing business with those kind of companies.
I think, Senator St. Nicholas, I think you bring up a good point, but also consistent with what the superintendent just shared with us. In terms of specifics, the responsive offer shall mean the offer that conforms at bid opening in all material respects to the solicitation. So in this particular case, if they're going to go out for the A&E, it would incorporate those and delineate all of those requirements. Once they go out for an IFP, then that would delineate all the requirements. It's just trying to not restrict the process when in fact there's already procurement rules and regulations in place and laws that dictate how this process should be carried out in a different section, and that was referred to as Title V. So that's one of the reasons why these additional specific items is being deleted from the law to ensure that there's consistency between this legislation and the existing procurement law. Because otherwise there may be questions raised about possible inconsistencies and deficiencies or whatever the case may be. So that's one of the reasons why this was agreed upon in terms of looking at ensuring that the existing law provides as much flexibility transparency and openness to be able to ensure that the people's interest is protected. And I believe Mr. Fernandez also had some additional comments.
I would just want to reassure the Senator that nothing precludes us from incorporating this as as material terms in the solicitation itself. I think the complication I'm referring to is that when it becomes a legal definition that is not necessarily that is above and beyond what is normally adjudicated as terms in terms of procurement with the OPA and the courts, it just creates an avenue by which you can start to find ways to challenge this legal definition. So the material, when the substance of it, the hard, construction costs, the soft costs, the lease payments, those items ought to be included in the solicitation itself. But I think the definition this language went beyond that by making it a legal definition and narrowing the definition of responsiveness.
Senator St. Nicholas, you start the floor.
Thank you, Mr. Chair. And I do appreciate that response from the superintendent, because if we evaluate it in that context based on what is being presented here, it's important for us to look at Section 4 and what does the solicitation require, because the solicitation itself does not require a breakdown of any of these things. It only requires the design, construction, management, financing of the facility, and there's nothing in the law that requires those specific areas to be broken out. It says that the solicitation shall specifically state the minimum specifications that will be required for a proposal to be considered, but those minimum specifications do not include a requirement to have transparency in any of these items. And when I evaluate the broad language that we have here in the solicitation, in the context of what was shared earlier, Mr. Chairman, for example, the superintendent commented that he wants to go out and do the design first. But based on the solicitation here on page 4, that's included in what is part of the solicitation. And in the way this language is written, it has to be under a 30-year leaseback arrangement. And so even the design has to be a part of the 30-year leaseback arrangement. So there's
Senator St. Nicholas, I know you're venturing into the subsequent section, but if you take a look at the verbiage in compliance with the Guam procurement law on page 4, line 5, for the design, construction, management, financing, renovation, or construction of the education facility under a 30-year leaseback arrangement. So that option is available there. Also on line 11, it reads, the solicitation shall specifically state the minimum specifications that will be required for a submitted proposal to be considered. So you're absolutely right in terms of looking at whatever proposal that GDOE, should this pass into law, it would be incorporated into whatever proposal is released out to the public for any solicitation. So just looking at this, there are provisions in here. If you take a look at this and you juxtapose it up to the procurement rules and regulations, that's where the flexibility is being requested by GDOE, so that in fact they are compliant with the procurement rules and regulations and the laws, and also consistent with these provisions and these allowances. So that's how, as a sponsor, we proceeded forward in terms of providing as much flexibility, but still ensuring that there are sufficient provisions in here that would address some of the concerns that you're bringing up.
In addition, Mr. Chairman, part of my concern is that the solicitor, which will be the Guam Department of Education, would no longer be soliciting through the Department of Public Works. And so the responsive offerer to the solicitation only needs to respond to an offer of solicitation made that was written up by DOE. And I mean, I love the Department of Education. I think they do a great job teaching our kids, but I just don't feel like they have the expertise to be able to draw up those kind of specifications to create the environment in which a responsive offer will be most suitable for the project.
Senator St. Nicholas, I know that was one of the issues that was brought up, and I'll yield to Mr. Fernandez, but all along during the consideration of Bill number 204, from day one, there was open communication with the superintendent insisting that the government personnel and resources that are presently existent in the government of Guam, that they still be available to be able to support this entire procurement process. So with GDOE maintaining oversight and pushing this process through, with the support of other government of Guam entities making that or being part of the consideration, that was a request that the superintendent had requested. So I want to also yield to him because he emphasized that more than a few occasions.
Yeah, if I could clarify, I know that's a question, and I want to make sure that everyone understands, because sometimes I get the question that people are still surprised that a GDOE has its own procurement authority, and when in fact we've had that procurement authority for a number of years. So on an annual basis, we actually procure $50 million, around $50 million worth of goods and services, both locally and federally funded. As you know, as part of the special conditions, we are under the third-party fiduciary, which is, which does review our progress in fixed assets as well as procurement. Right now, we've got about 7 and 8 member staff in procurement. All of them have been, per the law that was passed with, I believe, well, I don't want to get the sponsor wrong, but the law that was passed requiring that there be training and certification for all of those who are involved in procurement. We have 7 buyers, buyer supervisors, all of our legal team, our auditors who have participated in the GCC training and have completed all 4 modules. So I would say that with the volume of procurement that we already do, with the training and the progress that we've made, both on the local and federal side, that I would venture to say that we are ready to assume that responsibility for this procurement as well. Next to me, Mr. Romero is in charge of our CIP coordination, worked with the procurement of all of the work that was done at the schools relative to the ARA funds that were made available. So that involved renovation of Untalon Middle School. It involved the rooftop, the roof sealing and coating for all of our schools, electrical repair, and so forth. So I think I just want to clarify that it's not that we're new to procurement. We do handle a significant amount in terms of volume, and I believe that over the last 4 years, especially at the behest of the legislature, which initiated that law requiring certification and training, that we've made a lot of progress. And in fact, I've already completed 2 of the modules under GCC and passed and been certified. We'll finish with module 3 in June, and our deputies are going through the same training. So, I've had a lot of opportunity to sit with John Thomas Brown, kind of pick his brain on how these solicitations have gone awry and how we can improve them, and I think we're capable. So. I think that's how I would respond, just for the general public as well. This is not something that we're going to start from scratch in terms of knowledge and training, in terms of what is the basic procurement. We already do a significant amount of it.
Thank you, Mr. Fernandez. Senator San Nicolas, if you have one follow-on question, and then I'll come back to you after we circulate. We're still in section 2.
Thank you, Mr. Chairman. I understand that the department does a lot of procurement, but what we're talking about here is a solicitation for the building of a school. And the way this section 2 changes the existing language is that all you need to do is respond to the material respects of that solicitation. And what we're doing is we're saying that the Department of Education is the one that will draft up that solicitation. And I understand that, you buy a lot of stuff, you do a lot of maintenance, but there's so many specifications that need to go into the design and construction and the financing, so many technical aspects that need to be considered when putting together a solicitation that a responsive offer is going to be responding to. And if you miss even one point, then you can have an offer that is maybe not in the best interest of the community that is going to be considered responsive. And then when you go further along into how they will be selected, it's based on who has the lowest payment. And so if the solicitation is not airtight and this definition changes and the offeror is accepted and the payment is the lowest, they get get the award even if they're using the wrong grade of concrete for the roof. All because DOE put the wrong grade of concrete in the solicitation. And that's how technical this entire process is. And then we have a whole school built with the lowest 30-year leaseback payment that we're obligated for, with a roof that's going to fall in on the kids' heads that we're not going to be able to go into because DPW wasn't involved in the beginning, but when they go in at the end for the occupancy permit, they say, you guys didn't use the proper PSI. And then the contractor will say, well, that was in my solicitation, and DOE will turn around and say, well, we did our best. You know, and so that's why I'm raising these questions, because what we're doing here, and that's why I'm very worried, Mr. Chairman, about the pendulum swinging too far the other way. We've been gridlocked into this really awful protest environment that's choking our students up there, but I don't want us to swing the pendulum the other way and then create too much flexibility that's going to result in a project that could potentially dry up the very resources we're needing to get this thing done. So I'm concerned about the Section 2 watering down the definition of a responsive offer. I think knowing what the hard construction cost would be would definitely raise a red flag. If the hard construction costs are dramatically lower than everybody else, how are they doing that? Are they going to use lower PSI because it's cheaper than the harder concrete? You know, those kind of things. Or the soft costs. If the soft costs are much higher, is somebody getting some kind of lucrative management contract out of this? And you know, is that coming at the expense of maybe more water fountains that could have been in the hallways? And then the annual lease payment and the financing. I mean, those are all financing. Even in itself is a completely separate technical aspect to construction specifications. And so for all that to just get stricken through, and all we need is for a responsive offer to respond to the material respects of a solicitation, and to have only the Department of Education responsible for creating that solicitation, I'm very concerned that we may not have an outcome as ideal as we would like.
Thank you very much, Senator Sir Nicholas. I think there's a couple of things that we need to be very mindful of. First and foremost, there's one particular entity that has assumed the procurement of the Simon Sanchez High School for the last 7 years, because it started 7 years ago. And unfortunately, we are still 7 years far removed from any progress. So we're looking at other options. If you ask me if I have every confidence in the superintendent sitting to my immediate right, the answer is absolutely yes, because he has a direct stake in ensuring that the school facility that the Simon Sanchez High School students are presently being educated in needs immediate repair, or not upgrade, but replacement. Then who would have the greatest incentive to be able to ensure that this process moves forward? And in terms of the response that was just shared about the responsive offer, I want to remind our colleagues, let's take a look at this in totality, please, because you're right. Responsive offer with the respects to the solicitation with Mr. Fernandez, the superintendent, and all of his team members, inclusive of some of the external agency representatives, would put together a package. That solicitation now would go out to bid, would enumerate many of the items that you just highlighted that are proposed to be deleted here, but is provided for or would be provided for in other sections of the code in the Guam law. So I'm looking at it from that perspective in terms of providing the superintendent as much flexibility within law that he would be able to carry out and ensure that we try to move forward without any further complications or protests or delays in the construction of Simon Sanchez. So I hear your concern, Senator. In this particular case, those are specific items that really should be part of any solicitation or any bid that goes out. And in this particular case, it would be open to the public with all the people resources that would be available to Mr. Fernandez. So I would like to recognize Senator Espaldon. Thank you, Senator Sir Nicholas. On Section 2.
Thank you, Mr. Chairman. Under Section 2, there was discussion previous about the definitions and the reason why we need to perhaps change that, and that's the reason why there's been a strike through. And Mr. Fernandez, you made some good points. I mean, what is unconditionally undertakes? What is the definition of that? Is that protestable, or is that at least questionable? You also pointed to a complete breakdown, that phrase, right? I guess the question is, you know, under this, there's two things that kind of stick out right at the start. On the first line, it says response to the offer shall mean an offer that conforms at bid opening. The bid, I guess, to my understanding, that this would no longer be under an RFP, it would be under an invitation to bid or invitation for bid, right? IFB? Is that how this should be interpreted? That it no longer will be an RFP, it will now be under an IFB?
So I guess, let me back up one step. I guess the issue for me is, I'm not asking for any greater flexibility than currently exists in procurement law and regulations. So by principle, whenever we create a special definition for a particular solicitation, you raise the risk of diverting to a definition that has to be adjudicated de novo. So what I'm suggesting is that it might be fine and make sense for the legislature to say that the building ought to be purple and make that a legal definition, but that's still going to raise challenges. I mean, we might all think that we understand the term, but unless that's somehow been, you would be saying this is material, I'd say, boy, just adding some new language to our procurement law and regulation kind of ties my hand and raises the specter that someone's going to find a way to take that definition and say, well, that's not exactly what you meant or what you intended or what you said in the law. So what I'm saying is that by relying on the existing language in procurement law and regulations, there are two things. Number one is we don't create special terms and definitions that have to be adjudicated fresh. And number two, there should be a body of work already in hand by the OPA and
Mr.
by
Fernandez,
the courts.
my question is specific to the term bid. Does that imply an IFB?
So it depends, right? So on solicitation for professional services, you would typically go for a request for proposal, right? So that's, or you could use a multi-step process by which you qualify the bidders and then move to evaluation of the cost proposal. So I think in this case, if we're looking at design and architecture and engineering services, that would be an RFP for those professional services. They wouldn't be your common goods and so forth. If we went into simply the construction and financing component, you would move into, I would suggest that we do a multi-step process by which you basically qualify those under responsible and responsive offers, and then be able to move after you've determined those who are qualified, move into the cost proposal phase where the law already specifies what the basis of that evaluation should entail, which is the annual lease payment. So I think that's, so it depends what you're talking about, but I mean, that's the...
Well, I mean, we're talking definitions, because the whole gist of why I went into this was because we were talking about definitions when you were talking to the previous senator. And so now if we're talking definitions, because if there's been misinterpretations or it raises a whole new specter of issues because it's not clear, right? Specifically, you mentioned the term under existing law, unconditionally undertakes. What does that mean? Complete breakdown, what does that mean? So I just now, if we change the language, and the language now is actually very simple, it's simplified, but the question then becomes, does it raise another issue, as simple as it is?
Right.
Is a bid, right, when it says here, at bid opening. Now, I guess the question, a more simple question is, a submittal under RFP, is that a bid?
So let me refer you to the rules and regulations and the laws. What we're saying is all of that is determined by existing law and regulations.
Right, and you knowing and
Right.
having been on top of this and been part of the process, what is the answer?
So when we went out, based on the direction of the legislature, we did an RFP, which was dictated by the legislature, and it was all-encompassing.
Right.
So what I'm asking for is if we give the authority, we would sit down and with the authority to solicit these various components, because it's not just design, there's the comprehensive capital improvement plan and so forth, determine whether these are goods or services, and we would follow the procurement law relative to the method of source selection.
Okay.
So I think in the case of where it is professional services, they ought to be procured by an RFP, and if it's goods that we're procuring, so that's the answer. The answer is we have a whole body of law and regulation already set forth to guide us through this process. The only issue is making sure we execute per this guidance.
To guide you through the process,
so in
depending
answer,
upon, Mr.
Senator
Chair,
Espadon, so in direct response to your question, one of the concerns that was expressed by the superintendent, or one of the requests, is to provide the agency with flexibility, either utilizing the RFP process, which is already dictated through the procurement laws, or the IFB. So provide that flexibility so that, in fact, the agency can ultimately make that decision in terms of moving forward. So in response to your question, the flexibility is incorporated into this particular proposal to allow the superintendent to proceed.
And I appreciate that answer, but the question is actually quite more simple than that, right? If you issue an RFP, right, a request for proposal, and you open it up, is that proposal considered a bid? I mean, if we're going to talk about the interpretation of words, so it doesn't raise any protests, right? And that's why I'm very specific right now about the term bid. If it says conforms at bid opening, I would argue, if I was, depending on which side of the table I was on, right, that requires an invitation to bid, right, as opposed to an RFP. And so the question is, do you know whether an RFP, and I understand, you know, when you can use an RFP because that's in the procurement law or set by precedents and everything else, but if you read it by the strict letter of this legislation, and is at bid opening mean that we're opening a bid, which would fall under an invitation to bid, as opposed to an RFP or RFQ, an invitation to quote, right? So, and again, the question is just to make sure that there is no other definition for what these words are. Because if we're going to simplify it or bring it down and change the definition from what it is now existing in law so that we can avoid any protests on interpretation, the question is, does the word bid mean that the submittal was through an invitation to bid?
Mr. Fernandez?
So right now we are contemplating the method of procurement for each of these pieces, and I've specified how we might approach that. So if your question is whether or not it would be considered, I understand, I'll get to, I think what you're saying is that is this definition restrictive in some other sense? Right. The intent of reverting to this definition was to include a reference to responsive, but it was meant to reflect the existing procurement rules and regulations. So I think the issue is, that's the issue. So if there's any, I think we would want to determine whether there's any discrepancy in that definition, but we're relying on what is already existing language in procurement laws and regulations. So that's the definition we're relying on. Okay. And then as we go through procurement, we would determine how to apply that definition versus finding a different way to apply this new definition.
Right.
Senator Espadon, did you want to expand that particular verbiage? Because well, I understand now your specific question. Yeah. Right. At bid opening versus at bid / proposal opening.
Right. Yeah. Or in something to the effect in conformance with procurement law. So, whatever it may be. But again, if we get very strict on a bid and that becomes the issue, that an opposing attorney or one attorney might say, hey, this says bid. And, depending on the methodology that you use, if it wasn't an invitation to bid, then all of a sudden they have an issue.
Yeah, so, no, absolutely. Now that I understand kind of the gist of it, absolutely that language in conformance with procurement law and regulation would be completely in line with what we are intending.
Okay. Mr. Chair, I don't have the language right now for that amendment. I request that I'll be able to come back and perhaps make that, or if one of my colleagues would like to make that, or if you yourself would like to make that, and that'd be fine. And again, just to make sure that we don't fall into a dispute over definitions at the simplest terms, right? And, and that was the reason for that line. Because even the next issue, or the next set of words, and it's actually two words, basically opening in all material aspects. Now, I would imagine that's material aspects. Is that defined in procurement law?
So, yes, it is. Okay. But again, if you are looking to clarify that it is supposed to conform to existing procurement laws and regulations, that would be acceptable. That's in line with what we intended.
Okay.
Not to create new ones, but just to rely on the existing definitions that are
Right.
already
I mean,
adopted.
I would imagine that if we can at least get as succinct as possible so that there is less room for a protest, depending on words, you know, then at least we can go down that road and feel a little more comfort that at least we've eliminated that possible protest. Thank you, Mr. Chairman.
Thank you very much, Senator Espadon. I'll entertain an amendment at a later time if you
Thank
would like
you.
to come back. Or did you want to address it at this time?
I'm not sure what the appropriate wording would be. I might have to go with legal counsel's advice on this one, so during a break I might approach him and ask him what would be the best verbiage.
Thank you, Senator Espadon. Any other questions or comments with regards to Section 2? Vice Speaker Talai, you recognize.
Thank you, Mr. Chair. I just want to point out that Section 2, when we had the public hearing on this bill, shoot, where did I put it? Gosh, I just rearranged my file. If you would just give me 1 minute, I misplaced that now.
I'll come back to you,
Yes.
Vice Speaker Talai. Senator San Agustin, you recognize.
Yes, Mr. Chairman. The procurement laws and case laws will be in full effect. Am I correct, Mr. Fernandez? Basically, that's what you're basically asking for, right?
That the current procurement laws and regulations that apply to all procurement be in effect for this. Yes.
Okay, and GDOE will have the technical assistance from the DPW and other relevant agencies and legal counsel, correct?
Correct. There was some question about, you know, our role and the team members. We want to make sure that we continue to collaborate on this effort.
The reason why I'm asking these questions, Mr. Fernandez and Mr. Chairman, and I'm the co-sponsor, is that the bill basically brings it back to basic. So we don't add any more, we don't tie anybody's hands in getting this procurement going. Am I correct?
That's the intent, yes.
Okay, so I just wanted to remind my colleagues that if we want to question the procurement process, then maybe we need to ask the procurement folks to come in and ask them, does this meet all the basic procurement requirements? And if it does, then let's move on. And let's not put no more obstacles, and let's not go beyond 7 years that we've done it, that has already happened with Simon Sanchez. Because the deputy is not the same deputy from before. And his hands were tied, and this will untie your hands when you participate with the superintendent on this procurement. Thank you.
Thank you very much, Mr. Chairman of Education. Vice Speaker Talai, you recognize.
Thanks. I just want to read the testimony from the hearing. This is from Seville and Tang, PLLC, that says, Bill 204-34 deleted a critical definition regarding the definition of what constitutes a responsive offer and repeals the definition of responsiveness, both enacted by Public Law 34-19. So the superintendent is correct that this was just put in recently. And I think if we go back to that record, we're going to find that that was put in response to the protests. And it was our attempt to ensure, because of all the discretion, as the superintendent describes, that he will have, or that DPW had, that they had all this discretion, and so then the legislature decided to mandate that these things would be part of the solicitation, so that we would see, that the people of Guam would then see the hard construction costs, soft construction costs, or soft costs, and the rest of the items listed, because it was not necessarily required in the previous solicitation, and until they amended this law. And I'm not asking a question yet, but so I want to continue. So they said, the bill also refers to this solicitation as a general solicitation. It should also be made clear that the solicitation should be by invitation to bid, not a general solicitation. Now, understand, I think that's where some of the previous questions come from. It's like testimony from the superintendent tells us that they want the flexibility to do anything they want. A bid at certain points, an RFP at certain points.
Madam Vice Speaker, if I can inject, he's asking, the Superintendent of Education is asking for flexibility so that whatever mechanism he can use or DOE can use within compliance with the procurement rules and regulations, whether it's RFP or IFP, then that would be available to DOE.
I have no question.
They're going to drive.
I'm just
Order,
making
Mr.
my
Chair.
statement, Mr. Chair, if I could.
Please proceed.
Are we
Can
going?
I ask? Sorry, point of order, Mr. Chair. I just want to know your role.
Please state your point of order.
Here. From my understanding, I think that you are to facilitate the.
Senator Nelson, I mentioned a little earlier as
Yes.
part of the rules of engagement that yes, I will facilitate, but as a sponsor, I would apply discretion in terms of responding to certain questions.
Then
and
perhaps I would
statements.
ask you to I would ask to remove you as the chair if you are going to, since you are the sponsor of the bill, if you're not going to facilitate, but
Senator Nelson,
You know what I'm
I've been
getting at.
facilitating this conversation, but like I shared a
but
little
you're
earlier,
debating. You're no longer facilitating.
I'm
you're
making a
starting to
statement.
debate.
I'm making a correction. So that was the response. Senator Vice Speaker Talai, you still have the.
Well, I just wanted to point out that there are several issues that were brought up in testimony that are not made clear in the committee report as to why we did not adopt those recommendations and in general, I'm just going to state that I heard what the superintendent had to say. I also, understand that the discretion that we've given in our procurement laws to the Department of Public Works is all based on, we're debating a theory here. The theory of, do we still have faith that the Department of Public Works is supposed to be the sole entity in charge of procuring capital improvement projects for the government of Guam? And are we going to continue to allow them that discretion, to allow them to maintain or, establish that expertise, or have we lost confidence in them for just this project or all projects? Because we have not changed the procurement code for the rest of the projects. And personally, I know that we have a lot of turnover. This project began in 2014. And so we've had turnover of people who are on these committees, perhaps, maybe the deputies or the directors or the deputy directors changed. I'm not sure about all the players, but all I know is we're talking about entities of the government, but as to this one section, I just think that this was put in as a protection for the people because of the discretion that goes along with the procurement code, and that we saw it fit not too long ago. Just the 34th Guam Legislature saw it fit to include additional requirements in the solicitation so that we would know what the actual cost of these items are, instead of an overall blanket cost for the, in their offer or in their bid. I think that's the reason why. And so while I heard the superintendent's, intention why he wants to go back, and I'm a lawyer, so I understand what he's saying, that we can use interpretations of this exact language if it is the exact language that's used in the procurement code, and I think we're asking legal to confirm that. Then we can use prior interpretations, but I don't think that the part that's being struck out, the part that he wants to remove, I think there's still value for the people of Guam and value for all of us to know, to require that these things are included in the solicitation, and not to leave it totally at the discretion, because we did that before, and we ended up in protest, and we ended up in, debating whether we're really getting a good deal or we're not. And I think this is just to help us to also be able to take a look at whether we're getting a good deal or not. That's all, Mr. Chair. On
Thank you
this
very
section.
much, Vice Speaker Talai. Any other questions or comments on Section 2? If not, Senators, we're moving to Section 3. Questions or comments on Section 3? If not, Senator San Nicolas, you're recognized.
Thank you, Mr. Chairman. I can see how Section 3, the subsection 2 that's being stricken through may be a little cumbersome, but I'm looking at the lines 20 to 21, Responsive shall mean conforming in all material aspects to the purchase description and contract terms contained in the solicitation. I don't see how that is overly cumbersome. And, you know, in the interest of trying to not tinker as much as possible, if we could perhaps consider retaining that section, lest anybody can offer input as to why it needs to be stricken through as well.
Right, I'm not sure. I think if the language is to reflect conformance to existing procurement laws and regulations, and I think that particular section, conforming to material aspects, does. Again, subject to confirmation with your legal counsel, that would be fine. I mean, that would go towards the intent. It's the other language that was a little bit more specific and restraining that we had an issue with.
Yeah, in reading that section 2, subsection 2, I can see how that may be a little over the top there, but just to read into the record, Mr. Chairman, this item I'm talking about just simply reads, responsive shall mean conforming in all material aspects to the purchase description and contract terms contained in the solicitation. And so I would think that leaving something like that in there is fine, because if we're otherwise allowing offers to be considered responsive even if they don't conform to all material aspects of the purchase description or contract terms, I would actually be quite alarmed about that. So if we can perhaps consider not striking through the items on lines 20 and 21. But prior to making that amendment, Mr. Chairman, I'll just like to, I guess, bookmark that, and then we can come back if there's anybody. Perhaps the superintendent might provide greater clarity later on in the discussion.
Did you want to propose an amendment at this point in time?
I would, but bookmark, because the superintendent suggested that it may have been advised as a result of uniformity with existing procurement codes. So I just want to, if there's any kind of clarification, I'd like to afford a more available time for that.
Yeah, if you take a look, well, it's in the same code, subsection 58D 103(1), and then this would be, L, and then this would be sub-item M. So if, in fact, the verbiage in conformance with procurement rules and regulations is inserted into section 2, that particular phrase, then it may be repetitious in nature. But if you would like to consider that and reinstate that, then I will entertain an amendment at this time.
Sure, Mr.
So it would read, Senator St. Nicholas has an amendment to read, please revert back to the title, Guam Code Annotated is hereby amended to read, and just retain sub-item M1.
M1, lines 20 and 21.
Or I'll ask legal counsel to ensure the proper presentation, because the verbiage right now is both 1 and 2. So it may reflect just the deletion of number 2.
Right.
Okay, on that amendment, any objections? No objections? So ordered. Thank you very much, Senator St. Nicholas. No other questions or comments on section 3. We will proceed to, yes, Vice Speaker Talai.
Mr. Speaker, on section 2, I'm trying to find in the code where this language matches code language, and I'm not finding that. I find responsive bidder means a person who has submitted a bid which conforms in all material aspects to the invitation for bids. And then there's a definition for responsible bidder or offerer. But I'd like to continue to read, and maybe we could take a break. I move that we recess at this time.
Thank you very much, Vice Speaker Talai. We will come back to you shortly upon resumption after recess. The legislature will recess until 2 p.m. 2:15 p.m. Thank you.